Welcome back to another episode of Justice for Y'all. I'm Paul Painter, and with me, as always, is Andrew Bowen. Andrew, how you doing today?
I'm doing good, Paul. What are we going to talk about today?
Well, I think we're going to talk about the importance of having an eye towards appeal during a case and trial. Why don't you tell us a little bit about it?
You're tuned into the podcast where justice meets Southern hospitality, broadcasting directly from Savannah, Georgia, where your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
Well, most lawyers don't think about appeal until it's too late, until they're faced with an appeal. And by the time you're thinking about it, the problem usually isn't what is the appellate court doing. The problem is what did or didn't happen at the trial court. We had a case earlier this year that ended up in front of the United States Supreme Court, the ultimate appeal. And we've talked about it on the show, so we're not going to relitigate it here today in this episode. But it sharpened something that we already believed, and that's that cases like that are not won on appeal. They're built years earlier in the moments that might not feel all that significant when they're happening, but end up being critical on appeal. So, it's an objection that doesn't get made, a ruling that doesn't get pushed, evidence that doesn't get properly put into the record. And in the moment, you're thinking about the jury, your flow, your persuasion, the momentum of the trial. You're not thinking, how's this going to read to a panel of judges 2 years from now? But that's exactly the point. Appellate courts don't see your theme. They don't see your presence in the courtroom. They see a record. And if something's not in that record, it doesn't happen. It didn't happen. So today, how trial lawyers should think about appeal from day one. Where do cases get quietly won or lost before anyone files a notice of appeal? And what should you actually be doing differently?
These are great questions. And so we're talking about two things, really. Setting up your record during the litigation and then setting it up during trial. And we'll talk about both those things. But before we get into it, do you have any, share with the audience a little bit, maybe a story that you've had in trial, more fun in trial than, some deposition, that you can think of that you had to have an eye towards, all right, what's the Court of Appeals going to do with this?
Right. And sometimes it's not even what is the Court of Appeals going to do with it. It's how can we avoid the appeal altogether?
Yeah.
So an example of that is in a medical malpractice case we tried a couple of years ago. It was a wrongful death case. And there's a great old case. It's still good law, but it's an older case talking about Georgia's wrongful death statute. And the case, the court, I believe it's the Supreme Court, said in that case that the wrongful death statute is punitive in nature, and it's designed to prevent other negligent deaths. And so we crafted a jury charge basically saying that. And, it's good law, so it should be an appropriate charge. But when it came down to it, we looked at it and say, if we get a verdict in this case, which we ultimately did, that's the charge that the defense is going to appeal. And it may be something the court wants to look at and overturn that old case. And so discretion being the better part of valor, we said, let's just pull that charge. We don't need to push that.
Yeah. And it turns out they end up paying that verdict and not appealing it, which I'm not sure would have been the same way. If
well, that's exactly right. We got the verdict, a little over $6 million, and there was no appeal. They settled after trial.
That's right. Well, listen, to give a little context to this, let's start with the record on appeal. Okay, let's go to the appellate court first, and then we'll work our way down to how do you look at what's going to happen. So, that's one thing about trying cases is you learn a lot about how to litigate a case, knowing where it's ultimately going to be at a trial. Kind of works the same way with the Court of Appeals or the Supreme Court or whatever appellate court you're before. Let's talk about what is the Court of Appeals say looking at when, let's just take that case you were talking about. If that had been appealed, and it had been appealed on the jury charge that y'all ultimately withdrew, but if that stayed in and was appealed on that, what is the court looking at?
Well, the record, right? But what does the record consist of? It's transcripts of what was said, all written submissions in the case that were actually put on file.
It's like pleadings, motions, that kind of thing.
Correct. And then the evidence, and if it's pictures, if it's written evidence, documents, reports, I'm not exactly sure how they handle this, but if there's physical evidence in a case, I would assume that's something that the appeals court will actually have physically in front of them, or maybe it's just pictures or descriptions of it. That's actually a question I'd like to ask an appeals judge: is what happens with the physical evidence, which is part of the record on appeal.
We could have a whole different conversation about that, because they used to take the record. You used to have to go over to the courthouse and help put it together. The clerk would put it together, then you'd lug it home to write your brief. Then they'd send it up to the court. But anyway, now it's all digital. But we digress.
Right.
So they're looking at that, and the appellate judges and the appellate clerks, they're not really concerned about how you sounded to the jury. They're not at all
how charismatic you are.
That's right. They don't care about your theme of your case and what the vibe was in the courtroom while all this was happening. They're looking at what was said, what are the legal issues, what is the evidence and the documents at issue, and how does the evidence or the record support the arguments.
Right. And in the case of a jury charge, that if that was the specific issue being appealed, it's quite possible that the entire record wouldn't be designated. It would be the written submitted jury charges, the transcript of the charge conference, the transcript of the delivery of the charge to the jury, and then, importantly, if it was to preserve the objection, the transcript of the objection stated after the charge was delivered. So let me explain that.
Yeah.
If a party submits a charge in the charge conference, the meeting, where the court and the lawyers decide which charges are going to be used.
And let me just say, not every state uses the term charge. So
correct.
Talking about jury instruction.
Jury instruction.
The law that the judge reads to the juror.
So if there's one in there that one party thinks is not proper, then they have to object to it. If the judge ends up giving the charge regardless of the objection, then most states, and you need to know the law in your particular jurisdiction, most states would require another follow-up objection after the charge is delivered to the jury. So after the judge reads it to the jury, he'd ask each party whether they have any objections, and it would be incumbent on the lawyer for the defendant in this particular case to stand up and say, Judge, we accept or we object to charge number 13. And so assuming all that's done, that's what the Court of Appeals would be reviewing on that appeal, is the transcript of what was said and the written submissions regarding that jury charge.
Right, because in that case, you're talking about the court's looking at generally the facts of the case. Does it warrant this charge? But also, is this still good law? Because the court may say, that case y'all found, that old Supreme Court case, say, well, really our modern wrongful death statute is not meant to be punitive, and so we're going to overturn that previous case. Well, in that case, now you got to go retry your whole case because you made a statement of law or had the judge read the jury statement of law that the court now does not find to be accurate. So as plaintiffs' lawyers, we do not want to go to the Court of Appeals as much as we really love the Court of Appeals judges and the Supreme Court justices. We don't want to go up there because our clients don't get paid till this is over. They don't want it dragged down. We don't want it dragged down. Our job is to prevent us going to the Court of Appeals or the Supreme Court whenever possible. But it's not always possible. So why does the record matter more than everyone's memory of it? Because, why can't we just say, judges at the Court of Appeals, but this is kind of what happened.
Right. Well, again, if it's not written down as part of the record, it didn't happen. The judge can't, or the Court of Appeals can't rely on what each party contends was said or contends was meant by a certain statement. It's got to be there for them to read it in black and white. The lawyer's statement about what happened really has little weight.
Yeah, really nothing. If it's not on the record, it doesn't exist. And so let's talk about how that comes to play. Let's start with trial. We're already into this. What are some of the ways that this comes up at trial? And I'll start us out if you don't mind. But
sure.
one of the things is, you think that any time an objection's made or a motion is made, that the court is going to rule on it. And that's what the judge is supposed to do. But a lot of times there'll be an objection, and then everybody will go up to a sidebar next to the bench outside earshot of the jury and make the objections, and then they'll sort of be, the judge will say, well, I think this is, this falls into this category, but doesn't actually rule on the objection. It's your job as the lawyer, especially if you get overruled, to say, Judge, did I understand that you're overruling my objection? And it's like, that's right. So
Right.
Make sure it gets on the record. The judges know that needs to be there. Because if the judge doesn't rule, even if the judge was wrong, you've waived your objection.
Yeah,
Because without a ruling, there's nothing to review.
Right. You have to be appealing a ruling or decision by the court.
Right.
That's important. And a lot of times, lawyers, either in the heat of the moment or just maybe they're reluctant to push the judge for whatever reason to actually get that ruling. But that's something you've got to do.
That's our job. We got to get that.
Sometimes, let's talk about motions in limine.
Okay.
You would think, and in some jurisdictions perhaps it is like this, but you would think that if you file a motion in limine saying, hey, we want this particular piece of evidence excluded, and the judge excludes it, that would be the sort of the end of it. But let's fast forward to trial, and let's say that you're the party that wanted the evidence in, or you're the party that wanted it excluded, and the judge didn't exclude it. The judge said, I'm going to allow it in, right? So the time comes in trial where the other party, the defense, is going to present that piece of evidence. And in most jurisdictions, you've got to object contemporaneously with that tender into evidence in order to preserve the appeal.
Right. So you're saying there could be motion in limine, which is, they're just evidentiary motions, before the trial that says, we want to exclude, all pictures of the left side of the car for whatever reason. And the judge grants that motion, and for whatever reason, it's the right thing to do. And then you get in trial, and the side who didn't make the motion starts to enter into evidence pictures of the left side of the car. You can't just sit there and say, oh, okay, well, I got this motion, so I'm just going to sit on it. You need to be objecting at the same time contemporaneously so it can be corrected in the moment. Generally, the appellate courts would rather the trial judge have an opportunity to cure a problem in the moment than spend, all the money it takes to retry a case and do all that.
Well, and then the other scenario is, Judge, we don't think the pictures of the left side of the car should come in, and the judge says, no, I'm letting it in. So fast forward to trial, the defense is tendering the pictures of the left side of the car. You need to object again. Just filing the motion in limine and getting overruled is probably not enough to preserve the record on appeal, preserve the objection.
And so that goes to the point too, when we're talking about making a good record. Well, one more thing about making a record, offers of proof, proffers. Talk a little bit about that.
Well, we had a situation come up where we had an expert who was teed up to testify, and the defense made an objection, and the court actually excluded the witness from testifying. And in order to preserve that issue on appeal, had we lost the case, now we didn't, but had we lost the case, we would have wanted to appeal that. But in order to preserve that, we had to make an offer of proof, or some jurisdictions or some people called it a proffer, of what this expert would have said. And there are several ways you can do that. Traditionally, the judge would say, no, I'm not letting this witness in. You would say, Judge, well, we want to make a proffer. He would excuse the jury. They would leave the courtroom. We'd put that witness on the stand and examine him and actually get his testimony as if he had been allowed to testify in front of the jury. So then it's in the record, and so when it goes up on appeal, the Court of Appeals can look at it and say, yeah, that evidence, that witness should have been allowed to testify, and that evidence would have made a difference in this case. And so that's what you need to preserve it. Same thing with documentary evidence that's excluded. You still need to proffer it into the record, even though it's not admitted at evidence for the jury.
Yeah, if there's a picture that you want that gets excluded or doesn't get admitted, you must go put that in the record to make sure, excuse me, that when you try to appeal that ruling, if the picture or whatever is not in the record, then the appellate courts say, well, we can't decide this one way or the other. We're going to allow deference to the trial court. One other way to do it with a witness, too, in many courts, is you don't necessarily have to call the witness and have them fully testify. Let's say there was a doctor that you were trying to call, and for some reason the doctor wasn't allowed to testify. With the jury out of the room, but on the record, you can say, I'd like to make a proffer. We expected, Dr. Jones to say that the plaintiff was, critically hurt in this wreck, and he injured, these 3 vertebrae, and that it would cause him permanent injuries and pain for the rest of his life. And if that's the gist of the doctor's testimony, that's enough. It just gives the idea of what was he going to talk about. But you got to make sure that you do give the salient points. If the salient point was it was going to require facet injections for the next 16 months, and you kind of leave that out, well, then you can't go back into the appellate court and say, well, this doctor would have said he was going to require these injections. So you got to have an idea of why you're doing these things, which kind of goes to the next point of, while you want to have your record protected and complete, you also want to know when not to make an objection. And kind of like your story with the jury charge of the wrongful death, when you don't want to push an issue that you may win. Because if your goal, as it is ours, is to not have the case appealed, then don't put in things you don't need that could be ripe for appeals. You may win the argument at the trial court, but, who cares if it's going to cost you another 1.5 years while it's up at the Court of Appeals, or maybe you get reversed on that issue.
Right. And, if it's something critical to the case, you need it to win, or you need it to make the damages what they need to be, then you just got to make that tactical or strategic decision. But, just as an example, your client is on the stand and the defendant asks them a leading question. Well, you can object and probably be sustained, but unless it's something important, you don't need to annoy the judge and the jury just to make an objection because you can. Now, sometimes tactically, you make the objection to maybe put the defense lawyer on his back feet, or to fluster them, although we usually don't play games like that. But sometimes it's something that you want to consider. But if it's not an important question, if it's something basic like, well, you live in Savannah, Georgia, don't you? That's a leading question, but it doesn't matter, right? Who cares? So, don't object to things like that unless it's critical or material in some way.
It's not a law school exam where you're trying to figure out, is this in violation of the evidence code? The objections based on rules of evidence are tools you use to further your case or prevent the other side from advancing their case. And if you're not objecting for a purpose, then you're just sort of setting yourself up for the who knows.
Well, you and I have both tried cases in California, and I'd say generally our practice is if we're going to object on specific grounds and give the grounds for it.
Right.
And in California, I think both of our experience was almost, well, maybe not every, but many questions are objected to just by rote. You'll ask a question and objection, leading, relevance, facts not in evidence. And, they'll rattle off 3 or 4 objections. And you're like, what are you even objecting to? And it's annoying, and I don't think it's useful.
No.
But it's common practice out there. You experience the same thing.
I have. Not every lawyer out there, but I've seen it. It's almost like you would protect a deposition record, but it's not helpful at trial, I don't think. And it gets old really quick.
Right.
I think to the jury, too. Which kind of brings into another point of...
Hold on 1 second.
Yeah.
I just realized I made a silly mistake when talking about leading questions and objecting to them. The example I gave was a defense lawyer questioning my client, which of course he can lead on that. What I meant to say is a defense lawyer questioning his own client.
I didn't even catch it. I guess we shouldn't. But let's go back to establishing the record, but in the context of, we're talking about some very technical things that need to be in the record, but you don't want to bore the jury with acting like an accountant trying to get all the pieces of the record in place in front of the jury. You want it to be smooth and have a flow. I think nowadays, over the course of the years we've been trying cases, we've seen the attention span just get shorter and shorter and shorter. So, what are some of the things that we do for that? And I'll give an example to kick us off. Some of our cases have a lot of exhibits in them, and that's typically documentary evidence or photographs. But
how many exhibits did you have in the Morgan trial out in California?
600.
Yeah.
Yeah. I mean, they weren't all used, but we had a lot. And so if you have these exhibits, and this happens a lot with photographs, okay? So you've got photographs of the vehicle or of the plaintiff or something like that, and you might have 50 of them, and you want them all into evidence for whatever reason. Maybe it's just completeness, but you want to have them all into evidence. Most of them, if not all of them, are going to be entered into evidence without objection. So there's a couple ways to go about this. One, in most courts, I haven't been before a court that hasn't made me do this, but makes the parties meet and confer beforehand to see what can we stipulate to the authenticity and the admissibility of the evidence. So if it's stipulated to, then it just gets in.
Well, you still say, we're admitting.
I know, and I'm going to get there in a second.
Right.
But and the other way is you kind of ask them, are y'all going to have, we're going to start tendering these exhibits. Are you, and in Georgia we say tender exhibits. Some people move to admit into evidence. It's all the same thing. But as the other side, are y'all going to object to any of these? And, we're about to put in 1 through 50. Just let me know. So we can handle it outside the jury. And it's usually on break, come back from lunch, you have a recess, something like that. There may be 1 or 2 that you need to argue about, but otherwise you'll go through on the record with the jury out and say one at a time, often very painfully, plaintiff's moves to admit, plaintiff's exhibit 1. No objection, admit it. And you go through each one. You
have a checklist.
Oh, yes. You have a written checklist, because we're as digital as we can be with this stuff, but we always have a written checklist that has a list of the exhibit number, the description, whether it was stipulated to either authenticity or admissibility, and then was it offered into evidence, then was it objected to, and then was it admitted. So we can track each one of ours like that, and if it hadn't been checked on that, it hadn't happened in our world.
Right.
Because you cannot rely on your memory on even a 2-day trial. There's just too many things going on, but certainly not a week or 2 or longer of did we get everything in. And usually we'll try to have like a paralegal following along too to make sure.
Right.
But anyway, the point is we do it all outside the presence of the jury. Usually the judge is all in favor of this. Defense lawyers don't have a problem. And then you go through the tediousness of getting through all that. And then when the jury comes back in, everything's admitted at this point. Okay, let's just assume 1 through 50 have been admitted into evidence. I usually tell the judge that I'm going to do this just so doesn't look at me like I'm crazy. But when the jury comes back in, plaintiff call their next witness. Before we call the next witness, Your Honor, plaintiff's tenders exhibits 1 through 50 into evidence. So the jury hears they are admitted into evidence. So when they go back to the jury room, they're not confused of why they have them.
Right.
And then no objection, entered, and they're admitted. And then you get on with life. But that makes it to where instead of an hour-long tedious business with the jury, you can handle that then. Another reason, one more thing on this, and I'll turn it over to you, but this is a great thing to use depositions for. If you have to get photographs authenticated or documents authenticated, once they're authenticated, they're admissible at that point. And you can do that in deposition the same way you do at trial. So if it's already been done in deposition, then they're ready to be admitted on the first day of trial. and you don't have to go through the pain of having a witness authenticate each and every one of them
Right.
at trial. And it just, then you just ask the witness the questions you want to ask instead of going through the whole technical part of getting them admitted, which the jury starts falling asleep during.
One other thing I want to talk about before we wrap up here, and that's about specific appellate counsel. We've used what we call them as embedded appellate counsel before.
Sure.
Because we have handled cases on appeal, but there are people who really specialize in it and are excellent at what they do. And they see issues just from a different perspective. And so what somebody like that can do, even before trial, early on in the case, they can really tell you these are the essential elements of your case, if it's a weird or different cause of action. Or, this is the evidence that you need, and this is what the courts look at in evaluating these cases on appeal. And then at trial, their sole job is to make sure that you don't do anything that's appealable and to catch anything that the defendant does that is appealable and make sure that you preserve the record. And that's a great comfort when you're in the middle of a long, complex trials to have somebody take that little bit of mental gymnastics off your plate.
Yeah. I find it one of the fun parts of trial to be able that you have to manage 100 things at once and then not show it while you're talking to the jury or sitting at the desk or whatever. But it can be overwhelming. And when we usually have appellate counsel involved, the cases are very complex. Mm-hmm. They've got complex legal issues, sometimes complex evidentiary issues. And they're not your run-of-the-mill car wreck or something like that. There's things that that the appellate courts are going to be touching this case due to something new, different, novel about how you're going with the case. So you want to make sure that once you get up to the appellate courts, that you've got a record that your appellate lawyer can work with that is not wanting for, oh man, I sure wish we had put this in the record, but we don't have this. So we got to work around it. No, you want every tool you can at that part, and
right.
That's just
and most of them, there are firms who do it specifically or largely on behalf of plaintiffs, mm-hmm. and for the most part, they're willing to work on a contingency. You're giving up part of your fee, but at the end of the day, it's worth it because you're going to wind up with a clean record and a winning case on appeal.
Exactly.
Paul, I told my suitcase the other day that we weren't having a summer vacation this year.
Yeah.
Now I'm dealing with emotional baggage. Thank you all for listening. It's another episode of Justice for Y'all.
See you next time.
Thanks for listening to Justice for Y'all. If today's episode resonated with you or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that we're committed to justice for y'all.